Art 74. The property relationship between husband and wife shall be governed in the following order. By marriage settlements executed before the marriage. By the provisions of this code, and by the local custom. Types of regime that may be included and how modified. Art 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of a marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Requisites for its validity, marriage settlement. Art 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage. Art 77. The marriage settlements and any modification thereof shall be 1. In writing. 2. Signed by the parties. 3. Executed before the celebration of marriage, and 4. Registered in the LCR and Registry of Properties. Laws that govern marriage settlement, nationality theory. Art 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply. 1. Where both spouses are aliens. 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located, and 3. With respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. Effects if marriage did not materialize. Art 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriages shall be valid. Marriage is a condition sine qua non. If there are provisions not conditioned by marriage, that will not be affected. Example: they recognized their child in the marriage settlement. Donation propter nuptias. 1. Must be made before the celebration of marriage. 2. Must be in consideration of marriage. 3. In favor of either or both of the future spouses. Limitation on donation propter nuptias. Art 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. Grounds for revocation of donation. Art 86. A donation by reason of marriage may be revoked by the donor in the following cases. 1. If the marriage is not celebrated or judicially declared void ab initio except donations made in the marriage settlements, which shall be governed by Article 81. 2. When the marriage takes place without the consent of the parents or guardian, as required by law. 3. When the marriage is annulled, and the donee acted in bad faith. 4. Upon legal separation, the donee being the guilty spouse. 5. If it is with a resolutory condition and the condition is complied with. 6. When the donee has committed an act of ingratitude. Void donations by the spouses. Art 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. Absolute community of property regime. When it will commence. Art 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation, express or implied, for the commencement of the community regime at any other time shall be void. What comprised the community property? Art 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. What are excluded from the community property? Art 92. The following shall be excluded. 1. Property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. Note: if property was acquired gratuitously before the marriage, that is included in the community property. If acquired during the marriage, that is excluded unless expressly provided by the donor or testator. 2. Property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. 3. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Charges and obligations of the ACP. Art 94. The ACP shall be liable for 1. The support of the spouses, their common children, and legitimate children of either spouse. Note: support of illegitimate children is the responsibility of the one spouse. Considered advances to the community property. 2. All debts and obligations contracted during the marriage by both spouses or by one spouse with the consent of the other. Note: mere knowledge is not enough because the law requires consent. 3. Debts and obligations to the extent that the family may have been benefited. Note: the benefit to the family must be direct. Mere indirect benefit is insufficient. If merely a guarantor, ACP is not liable. If family business, liable even if there are losses because the family may be benefited. 4. All taxes, liens, charges and expenses, including major or minor repairs, upon the community property. 5. All taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by the family. 6. Expenses for self-improvement. 7. Antenuptial debts insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of self-improvement. Note: it must be a donation coming from both spouse. If it only comes from one of the spouse, it can be considered as violation of the rule prohibiting donation between the spouses during marriage. 9. In case of absence or insufficiency of the exclusive property of the debtor spouse. A. Other antenuptial debts of either spouse. B. The support of illegitimate children of either spouse, and C. Liabilities incurred by either spouse by reason of a crime or a quasi-delict, the payment of which shall be considered as advances to be deducted from the share of the debtor spouse upon liquidation of the community, and 10. Expenses of litigation between the spouses unless the suit is found to be groundless. If the community property is insufficient to cover the foregoing liabilities, except those falling under paragraph 9, the spouses shall be solidarily liable for the unpaid balance with their separate properties. Cases. From the jurisprudential rulings of the court, we can derive the following conclusions. A. If the husband himself is the principal obligor in the contract, such as he directly received the money and services to be used in or for his own business or his own profession, that contract falls within the term obligations for the benefit of the conjugal partnership. Here, no actual benefit may be proved. Simply stated, where the husband contracts obligations on behalf of the family business, the law presumes that such obligation will redound to the benefit of the conjugal partnership. B. On the other hand, if the money or services are given to another person or entity, and the husband acted only as a surety or guarantor, that contract cannot, by itself, alone be categorized as falling within the context of obligations for the benefit of the conjugal partnership. No presumption can be inferred that, when a husband enters into a contract of surety or accommodation agreement, it is for the benefit of the conjugal partnership. Proof must be presented to establish benefit redounding to the conjugal partnership. Gambling. Art. 95. Whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winnings therefrom shall form part of the community property. Note: any winnings belongs to the community property benefits. On the other hand, any losses shall be borne by the spouse and charged to their separate property. Ownership, administration, enjoyment and disposition of ACP. Husband and wife are joint administrator. Art. 96. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. Note: when the spouse can be the sole administrator. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. In the absence of authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer. Neither spouse can dispose or donate a community property without the consent of the other spouse. Art. 98. Neither spouse may donate any community property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the community property for charity or on occasions of family rejoicing or family distress. Note: the sale of a common property by one spouse only is void. Case loss. The presumption of conjugality applies to property acquired during the lifetime of the husband and wife. In this case, it appears on the face of the title that the properties were acquired by Denata Montemayor when she was already a widow. When the property is registered in the name of a spouse only and there is no showing as to when the property was acquired by said spouse, this is an indication that the property belongs exclusively to said spouse. And this presumption cannot prevail when the title is in the name of only one spouse and the rights of innocent third parties are involved. Under the Family Code, the administration of the conjugal property belongs to the husband and the wife jointly. However, unlike an act of alienation or encumbrance where the consent of both spouses is required, joint management or administration does not require that the husband and wife always act together. The signing of the attached certificate of non-forum shopping only by the husband is not a fatal defect. If anybody may repudiate the certification or undertaking for having been incorrectly made, it is the wife who may conceivably do so. Without the wife's consent, the husband's alienation or encumbrance of conjugal property prior to the effectivity of the Family Code is not void, but merely voidable. Article 124 of the Family Code requires that the disposition of a conjugal property by the husband as administrator in appropriate cases requires the written consent of the wife, otherwise, the disposition is void. Respondent Norma may have been aware of the negotiations for the sale of their conjugal properties. However, being merely aware of a transaction is not consent. Dissolution of absolute community. Grounds for dissolution. Art. 99. The absolute community terminates. 1. Upon the death of either spouse. 2. When there is a decree of legal separation. 3. When the marriage is annulled or declared void, or 4. In case of judicial separation of property during the marriage under Articles 134 to 138. Effect of de facto separation on the ACP. Art. 100. The separation in fact between husband and wife shall not affect the regime of absolute community except that 1. The spouse who leaves the conjugal home or refuses to live therein, without just cause, shall not have the right to be supported. 2. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. 3. In the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. Effect of abandonment or failure to comply with his, her obligation to the family. Art 101. If a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court. A. For receivership. B. For judicial separation of property or C. For authority to be the sole administrator of the absolute community or conjugal partnership. Note: meaning of abandonment. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. Liquidation of the absolute community. Art 102. Upon dissolution of the absolute community regime, the following procedure shall apply. 1. An inventory shall be prepared. 2. The debts and obligations of the absolute community shall be paid out of its assets. In case of insufficiency, the spouses shall be solidarily liable for the unpaid balance with their separate properties. 3. Whatever remains of the exclusive properties shall thereafter be delivered to each of them. 4. The net remainder of the properties of the absolute community shall constitute its net assets, which shall be divided equally, unless a different proportion or division was agreed upon. 5. The presumptive legitimes of the common children shall be delivered upon partition. 6. The conjugal dwelling and the lot shall be adjudicated to the spouse with whom the majority of the common cases. As a general rule, any modification in the marriage settlements must be made before the celebration of marriage. An exception to this rule is allowed provided that the modification is judicially approved and refers only to the instances provided in Articles 66, 67, 128, 135 and 136 of the Family Code. The grant of the judicial separation of the ACP automatically dissolves the absolute community regime, as stated in the fourth paragraph of Article 99 of the Family Code. Under Article 102, liquidation follows the dissolution of the absolute community regime and the following procedure should apply. Effect if no liquidation is made after the death of a spouse on the subsequent marriage of the surviving spouse. Art 103. Upon the termination of the marriage by death, the community property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the community property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse of the 6 months period, no liquidation is made, any disposition or encumbrance shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. Conjugal partnership of gains regime. Concept of conjugal partnership of gains. Art 105. In case the future spouses agree in the marriage settlements that the regime of CPG shall govern their property relations during marriage. Art 106. Under the regime of CPG, the husband and wife place in a common fund the proceeds, products, fruits and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and, upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them, unless otherwise agreed in the marriage settlements. What are the exclusive properties of each spouse? Art 109. The following shall be the exclusive property of each spouse, excluded in CPG, GIBO. 1. That which is brought to the marriage as his or her own. 2. That which each acquires during the marriage by gratuitous title. 3. That which is acquired by right of redemption, by barter or by exchange with property belonging to only one of the spouses, and 4. That which is purchased with exclusive money of the wife or of T. Cases. Matthews v. Taylor. The rule is clear and inflexible. Aliens are absolutely not allowed to acquire public or private lands in the Philippines, save only in constitutionally recognized exceptions. Considering that Jocelyn appeared to be the designated vendee in the deed of sale of said property, she acquired sole ownership thereto. This is true even if we sustain Benjamin's claim that he provided the funds for such acquisition. Note that the constitutional prohibition only includes lands. Improvements built on the subject lands are not prohibited. Alien may own this. SPS are considered co-owners of the improvements. Case: the presumption that all properties acquired during the marriage, whether the acquisition appears to have been made, contracted or registered in the name of one spouse or both, are conjugal, remains until the contrary is proved. Ownership, enjoyment, and administration of exclusive property. What are the conjugal partnership properties? Art 117. The following are conjugal partnership properties. 1. Those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership, or for only one of the spouses. 2. Those obtained from the labor, industry, work or profession of either or both of the spouses. 3. The fruits, natural, industrial, or civil, due or received during the marriage from the common property, as well as the net fruits from the exclusive property of each spouse. 4. The share of either spouse in the hidden treasure. 5. Those acquired through occupation, such as fishing or hunting. 6. Livestock existing upon the dissolution of the partnership in excess of the number of each kind brought to the marriage by either spouse, and 7. Those which are acquired by chance, such as winnings from gambling or betting. Case: although it is not necessary to prove that the property was acquired with funds of the partnership, proof of acquisition during the marriage is an essential condition for the operation of the presumption in favor of the conjugal partnership. In the case Ruiz v. CA, this court ruled that the phrase "married to" is merely descriptive of the civil status of the wife and cannot be interpreted to mean that the husband is also a registered owner. Rules to determine conjugality. Rule on property bought on installment by one spouse before the marriage. Art 118. Property bought on installments paid partly from exclusive funds of either or both spouses and partly from conjugal funds belongs: A. To the buyer or buyers if full ownership was vested before the marriage, and B. To the conjugal partnership if such ownership was vested during the marriage. In either case, any amount advanced by the partnership or by either or both spouses shall be reimbursed by the owner or owners upon liquidation of the partnership. Rule on amount received by one spouse during the marriage as payment of credit. Art 119. Whenever an amount or credit payable within a period of time belongs to one of the spouses, the sums which may be collected during the marriage in partial payments or by installments on the principal shall be the exclusive property of the spouse. However, interest falling due during the marriage on the principal shall belong to the conjugal partnership. Rule on ownership of improvements made by the conjugal partnership on the exclusive property of one spouse. A. When the cost of the improvement and any resulting increase in value are more than the value of the property, the entire property shall belong to the conjugal partnership, subject to reimbursement of the value of the property of the owner spouse, otherwise. B. Said property shall be retained in ownership by the owner spouse, likewise subject to reimbursement of the cost of the improvement. Case loss. If the cost of the improvement plus the resulting increase in the value of the land is more than the value of the land at the time of construction, then whole property becomes conjugal subject to reimbursement of the value of the property at the time the improvement was made. As a general rule, all property acquired during the marriage, whether the acquisition appears to have been made, contracted or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is proved. While there is proof that Romerico acquired the properties with money he had borrowed from an office mate, it is unclear where he obtained the money to repay the loan. If he paid it out of his salaries, then the money is part of the conjugal assets and not exclusively his. Proof on this matter is of paramount importance, considering that in the determination of the nature of a property acquired by a person during coverture, the controlling factor is the source of the money utilized in the purchase. Charges upon and obligations of the CPG. Art 121. The conjugal partnership shall be liable for 1. The support of the spouse, their common children, and the legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this Code on Support. 2. All debts and obligations contracted during the marriage. 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have benefited. 4. All taxes, liens, charges, and expenses, including major or minor repairs upon the conjugal partnership property. 5. All taxes and expenses for mere preservation made during the marriage upon the separate property of either spouse. 6. Expenses to enable either spouse to commence or complete a professional, vocational, or other activity for self-improvement. 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement, and 9. Expenses of litigation between the spouses unless the suit is found to be groundless. Case. Medical expenses are conjugal partnership liabilities. Reason: the health and well-being of either of the spouses will redound to the benefit of the conjugal partnership regardless of the supposed abandonment. Where the husband contracts obligations on behalf of the family business, the law presumes, and rightly so, that such obligation will redound to the benefit of the conjugal partnership. Unlike in the system of absolute community where liabilities incurred by either spouse by reason of a crime or quasi-delict is chargeable to the ACP, in the absence or insufficiency of the exclusive property of the debtor spouse, conjugal property cannot be held liable for the personal obligation contracted by one spouse, unless some advantage or benefit is shown to have accrued to the conjugal partnership. Dissolution of the conjugal partnership. Art 126. The conjugal partnership terminates. 1. Upon the death of either spouse. 2. When there is a decree of legal separation. 3. When the marriage is annulled or declared void, or 4. In case of judicial separation of property during the marriage under Articles 134 to 138. Liquidation of the conjugal partnership. The disposition by sale of a portion of the conjugal property by the surviving spouse without the prior liquidation mandated by Article 130 of the Family Code is not necessarily void if said portion has not yet been allocated by judicial or extrajudicial partition to another heir of the deceased spouse. At any rate, the requirement of prior liquidation does not prejudice vested rights. In the case of Teninco v. Register of Deeds of Laguna, we held that the properties of a dissolved conjugal partnership fall under the regime of co-ownership among the surviving spouse and the heirs of the deceased spouse until final liquidation and partition. Thus, Anastasio, as co-owner, cannot claim title to any specific portion of the conjugal properties without an actual partition being first done either by agreement or by judicial decree. Nonetheless, Anastasio had the right to freely sell and dispose of his undivided interest in the subject property. Separation of property regime. When do you have separation of properties? A. If agreed upon in the marriage settlement. B. If the SPS secured a judicial authorization for the separation of prop during the marriage. Note: separation of property during the marriage can either be with cause or without cause. Art 135. Any of the following shall be considered sufficient cause for judicial separation of property. 1. That the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. 2. That the spouse of the petitioner has been judicially declared an absentee. 3. That loss of parental authority of the spouse of petitioner has been decreed by the court. 4. That the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family as provided for in Article 101. 5. That the spouse granted the power of administration in the marriage settlements has abused that power, and 6. That at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. In the cases provided for in Numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. Art 144. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. Art 146. Both spouses shall bear the family expenses in proportion to their income, or, in case of insufficiency or default thereof, to the current market value of their separate properties. The liabilities of the spouses to creditors for family expenses shall, however, be solidary. Property regime of unions without marriage. If no legal impediments to marry each other or the marriage is void, the regime is co-ownership. Art 147. When a man and a woman who are capacitated to marry each other, live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work or industry, and shall be owned by them in equal shares. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common, without the consent of the other, until after the termination of their cohabitation. Cases. Dinyo v. Dinyo. Article 147 of the Family Code applies to union of parties who are legally capacitated and not barred by any impediment to contract marriage, but whose marriage is nonetheless void, such as petitioner and respondent in the case before the court. For Article 147 of the Family Code to apply, the following elements must be present. 1. The man and the woman must be capacitated to marry each other. 2. They live exclusively with each other as husband and wife, and 3. Their union is without the benefit of marriage, or their marriage is void. In this case, petitioner's marriage to respondent was declared void under Article 36 of the Family Code and not under Article 40 or 45. The rules on co-ownership apply and the properties of the spouses should be liquidated in accordance with the Civil Code provisions on co-ownership. It is not necessary to liquidate the properties of the spouses in the same proceeding for declaration of nullity of marriage. Barredo v. Non-Auto 2014. Under this property regime, property acquired by both spouses through their work and industry shall be governed by the rules on equal co-ownership. Here, the former spouses both agree that they acquired the subject property during the subsistence of their marriage. Thus, it shall be presumed to have been obtained by their joint efforts, work or industry, and shall be jointly owned by them in equal shares. Therefore, the subject property remains to be owned in common by non-auto and Barredo, which should be divided in accordance with the rules on co-ownership. Art 148. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in both faith. Note, if you can prove your capacity to earn but you cannot prove the exact amount, the presumption is equal. Failure to prove contribution, no contribution. Case loss. Article 148 of the Family Code refers to the property regime of bigamous marriages, adulterous relationships, relationships in a state of concubine, relationships where both man and woman are married to other persons, multiple alliances of the same married man. Article 148 provided that only the property acquired by both of the parties through their actual joint contribution of money, property or industry shall be owned in common and in proportion to their respective contributions. Such contributions and corresponding shares were prima facie presumed to be equal. However, for this presumption to arise, proof of actual contribution was required. The same rule and presumption was to apply to joint deposits of money and evidence of credit. Article 147 differentiated from Article 148. As to applicability, in Article 147, the following must concur. 1. That the man and the woman must be capacitated to marry each other. 2. They live exclusively with each other as husband and wife, and 3. Their union is without the benefit of marriage, or their marriage is void. On the other hand, in Article 148, it is applicable in cases of cohabitation not falling under Art. 147. Parties are not capacitated to marry each other due to some legal impediments, although it may also fall under a void marriage. Incestuous. Void marriages against public policy under Article 38. Void marriages under Article 35, paragraphs 1 and 4. Bigamous marriages under Article 41. As to distribution of as to property acquired while living together. In Article 147, properties are presumed to be obtained by their joint efforts, work or industry and shall be owned by them in equal shares. Efforts in care and maintenance of family and household considered contribution in acquisition. While in Article 148, there is no presumption of joint acquisition. When there is evidence of joint acquisition but none as to the extent of actual contribution, there is a presumption of equal sharing. Judicial separation of property. Art. 135. Any of the following shall be considered sufficient cause for judicial separation of property. 1. That the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. 2. That the spouse of the petitioner has been judicially declared an absentee. 3. That loss of parental authority of the spouse of petitioner has been decreed by the court. 4. That the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family. 5. That the spouse granted the power of administration in the marriage settlements has abused that power, and 6. That at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. Case loss. The separation of property is not effected by the mere execution of the contract or agreement of the parties, but by the decree of the court approving the same. It, therefore, becomes effective only upon judicial approval, without which it is void. This court has ruled that the extrajudicial dissolution of the conjugal partnership without judicial approval is void. The court has also ruled that a notary public should not facilitate the disintegration of a marriage and the family by encouraging the separation of the spouses and extrajudicially dissolving the conjugal partnership. Art. 137. Once the separation of property has been decreed, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with this code. During the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. Voluntary separation. Art. 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains, and for the separation of their common properties. Art. 141. The spouses may, in the same proceedings where separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property in any of the following instances. 1. When the civil interdiction terminates. 2. When the absentee spouse reappears. 3. When the court, being satisfied that the spouse granted the power of administration in the marriage settlements will not again abuse that power, authorizes the resumption of said administration. 4. When the spouse who has left the conjugal home without a decree of legal separation resumes common life with the other. 5. When parental authority is judicially restored to the spouse previously deprived thereof. 6. When the spouses who have separated in fact for at least 1 year, reconcile and resume common life, or 7. When after voluntary dissolution of the absolute community of property or conjugal partnership has been judicially decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. The revival of the former property regime shall be governed by Article 67. Thank you for watching. Property relations under the Family Code. Next video is about the family under the same code.